In the early 1990s, the Supreme Court decided, in an opinion written by Justice Antonin Scalia, that if a government rule applies to everybody, doesn't single religion out, so is neutral and treats everybody the same, then there's no free exercise objection. There is no constitutional problem with its application toward exercise of religion.
You're listening to Law and the Pandemic, a production of UC Hastings Law School and its Center on Legal Technology and Innovation, LexLab. We're your co-hosts. I'm Drew Amerson.
And I'm Arika Smith. Today we asked Professor Matt Coles, can they do this? To get his take on shelter-in-place orders and the Constitution. Before joining the UC Hastings Law faculty, Professor Coles was Deputy National Legal Director at the ACLU. He also helped defeat 3 California ballot initiatives aimed at quarantining people with HIV in the 1980s.
Professor Coles, thank you for joining us today.
Pleasure.
You teach at UC Hastings in San Francisco, and it just so happens that San Francisco, along with the 5 surrounding Bay Area counties, were the first in the U.S. to issue a shelter-in-place order, and that was back in mid-March, I think March 16th. It's almost 6 weeks now. It seems to have had a positive effect. Our hospitals aren't overwhelmed. We flattened the curve here, but it has come at some cost. We're all working from home. We're teaching our kids from home. There are plenty of people who can't go to work at all now and have been laid off. There are tens of millions of people in the United States who are unemployed. So my first question to you is, can the governments do this? Can they make us all stay at home?
So the way to think about that from a constitutional standpoint is to ask the question, has the government interfered with our liberty in violation of the Due Process Clause of the Constitution? 5th Amendment as to the federal government, 14th Amendment as to the states. And you want to start with this understanding that the liberty that's protected by the Due Process Clause, it's not the right to go anywhere anytime that you feel like it. And just thinking for a second about the way society works, you can see that, right? Folsom Street is, the government can make Folsom Street one way east, and I can't drive west on Folsom Street. The government can close the park at 5 o'clock, and I can't insist that I be able to go into it, right? So violations of liberty like that don't get much serious attention under the Due Process Clause. On the other hand, if the government were to take you and to confine you, to put you in a government locked facility and say that you have to stay there for as long as the government says, that does raise very serious questions under the Due Process Clause. And while the shelter-in-place order, says that we can go out for exercise and go out to get food and medicine, it's basically pretty close to confinement. And it's confinement at home, not in a government facility. So I think courts would take a claim under the Due Process Clause quite seriously. And so you proceed to ask 2 questions. And the first question is, well, does the government have a really important reason for doing this? With that level of confinement, it can't be something casual or something optional. It has to be a really serious interest. But, the government's interest is preserving hundreds and thousands, perhaps millions of people from being killed in a pandemic. And I think the courts will say, yeah, that's an important purpose. And then the next question is, how well designed is the device the government's chosen to effectuate that purpose? How to what extent does it restrict basic liberty more than it needs to? To what extent could it be more tightly drawn? And in this kind of a conversation, what really counts in many ways is where responsible public health authorities are. If responsible public health authorities say, this is a reasonably well-designed measure to prevent those kinds of deaths, courts are generally going to defer over to that. They're not going to second-guess scientists and epidemiologists about what kind of devices you need or don't need. We saw this during the HIV epidemic quite a few years back. I had a motto, and my motto was, if we get public health on our side, we win. And if the other side gets public health on their side, they win. So, early in the epidemic, when a lot of institutions were saying that healthcare workers who had HIV couldn't work, and public health was saying, well, we're not really sure about vectors of transmission. We lost those cases. A little further along, when the science was better and public health said, the risk of transmission in a healthcare setting is small, vanishingly small, we won those cases. And I think that's going to be the word here, that if you had a rogue governor who was saying, even one death is unacceptable for a complete shutdown, then you could see a court stepping in. But as long as the scientists are saying this is a reasonably well-calculated measure. And the one thing you won't see the courts doing is you're not going to see the courts rebalancing the question of how many lives are worth saving for how much damage to the economy. That's a classic policy call. It's a kind of calculation, actually, that the government makes all the time. Anytime the federal government adopts a new regulation, they compare what the cost of it would be, and how many lives would it save, and how do we value those lives. And they actually have a formula for valuing people's lives. At this point, there's no question, using those approaches, that the damage to the economy is far, far outweighed by the value of all the lives that would be lost, or so the epidemiologists tell us. And again, courts are not going to get into reweighing that. I think the only way a court would get involved on shelter-in-place orders is if public health people were saying, you didn't actually need to do that. If we get to a point where public health people say, it appears that people can maintain social distancing and this level of social distancing, and so, you can open up stores, but you can't open up theaters, things like that. If the public health people were to get to a consensus view on that, and you had some governors saying, no, I still want to shelter in place, then I do think the courts would say, no, we're going to go with the public health people. But I think that's really going to be the gold standard.
Yeah, I guess I'm also curious about how other constitutional rights might play into this. As we start to come out of this first phase where it's a really strict shelter in place, we've seen some people pushing now to be able to go to church. How might that right be implicated here?
The funny thing about the right to free exercise of religion is in the early 1990s, the Supreme Court decided, in an opinion written by Justice Antonin Scalia, that if a government rule applies to everybody, doesn't single religion out, so is neutral and treats everybody the same, then there's no free exercise objection. There is no constitutional problem with its application toward exercise of religion. So the first thing that you hear people saying, well, church services are different. Even if you can't meet in a theater, you should be able to meet in a church because of the First Amendment. That's just wrong under constitutional law that was largely driven by conservative members of the Supreme Court. On the other hand, if you singled religion out, right, if you said, well, theaters are okay, but not churches, that would clearly fall quite quickly. I think we've seen some creative approaches by some churches. There were some churches in the South that did drive-in services, rented. There are still drive-in theaters in America. The rented drive-in theaters. And, I think, again, if public health people say, yeah, you can fill up the parking lot even with people in their cars, and as long as they keep the windows rolled up halfway, no serious threat, then I think the courts would say, all right, well, then you can't ban people from doing that. But not really because it's religion, because it's that same liberty of movement, and it's the same serious restriction on liberty of movement. Now, most states have state constitutional provisions that protect religion more strongly than the federal Constitution does. But I think even under those, what courts are going to do is they're going to turn to the public health people and say, is this safe or not? And if the public health people say it's not safe, I think the ban is going to be fine.
Yeah, that's really interesting. I hear you keep coming back and saying again and again that the courts are going to defer to the public health experts. And one question that raises for me is, the public health experts aren't necessarily speaking in unison. If the governor of Nevada is getting different advice from the public health experts there than the governor in California is, how might that create some conflict between those two states? And at what point is there an issue with that?
Well, it doesn't need to have been this way. We have largely ceded the question of what kind of restrictions there ought to be over to state governments. And as long as the governor of Nevada could come into court and say, my public health people tell me that 4-foot social distancing is good enough. And my people tell me that even if that's not people passing, that's people sitting in a room. And so I'm going to issue a regulation that says you can reopen your churches as long as you have use every other pew and put 4 feet between. And again, as long as it's solid public health, I think the governor of Nevada is going to be able to do that. So I don't think the real gold standard in public health in the United States is the Centers for Disease Control, although they've had a spotty reputation coming out of the coronavirus pandemic. I think it remains the case that by and large, people look to the CDC for guidance. And, I think in a conflict between a municipal health officer and a federal health officer, if the federal health officer said what the locality wanted to do was dangerous, you'd probably default federally. If what the locality wants to do, all the federal government is going to say is, well, we don't think that's necessary. Things aren't that bad. I think you might get a court saying, well, it's a state issue if the state health department thinks X. If they're being more protective, I think if they're being less protective, probably the feds are going to be a backstop on it.
Gotcha. And I guess a question I have is, as we're coming out of this phase again, and we're hopefully going to start opening up and having less restrictive shelter-in-place orders, we've heard the health experts say that you need more testing and you need to be able to do contact tracing. So if you find a positive, you have to be able to go back and trace all of their contacts. I am interested in the implications of using technology to do that. So I know that Facebook and Google have opened up their platforms and said, we're willing to do this. Does that create any issues from a surveillance perspective?
Right. Well, contact tracing is really old-fashioned public health. It's the way public health has dealt with infectious diseases for 100 years. And as conventionally done, even mandatory contact tracing is somewhat voluntary, right? You have to sit me down and say, I'm required to tell you who my contacts are. But basically, the people who are listening to me have to take my word for it, right? They can't, they don't have any means, at least in classic contact tracing, to run it out, to find out. Generally speaking, contact tracing, I think even mandatory contact tracing, when there's something to do with the information, is also generally going to be upheld by the courts. I'll get to the technology, which I think changes things a bit in a moment. Right, but if public health is saying we need to ask you who your contacts are so we can contact them and observe them and see if they get sick, and if they do get sick or they show signs of getting sick, we can isolate them and treat them if we ever have a treatment. But so we can isolate them until they're non-infectious. I think courts are going to say you can do that. If you can do mass shelter-in-place, stay-at-home orders, doing much more targeted orders that turn on contact tracing, I think are probably going to be upheld as well. Where it gets tricky with technology, I think, something that really hasn't come up in public health is the question of whether the government is going to be able to use electronic information that it would obtain in order for other purposes than public health. Google and Apple have tried to protect against that by making their contact systems, effectively the devices they've created, voluntary, right? So I decide that the government can have access to the information, and that supposedly waives the privacy concerns. But I think there are two things wrong with that. One, it's not going to be very effective contact tracing if it's only done voluntarily. And number two, I don't think people understand that when they turn it over to the government, you need kind of built into the laws that allow the tracing a limitation that says to the government, you can't use this for anything else. If you can't, there's a case a couple of years ago in which the police departments used cell phone metadata, just to demonstrate that a person was close by a whole series of robberies against Radio Shacks. I know I almost have to explain what a Radio Shack is, but a retail store, right? And the court was very alarmed by that. And here too, right? If you simply turn over the bulk of all that data to the government, down the line, somebody might well say, let's run this stuff through a good computer system and see if we can begin to get patterns of behavior that might explain certain crimes, that might explain, serial rapists, that might explain people who are right? But it seems to be central, if you're going to use some kind of electronic tracing to do contact tracing, that you're going to have a solid pledge from the government. And I think that means an act of Congress saying only for this, and otherwise the information gets thrown away.
Yeah. Is there anything else that you think we should be thinking about as we look ahead to the next 6 months, year? What constitutionally will be an interesting issue that might crop up here?
Well, one thing that the virus, the pandemic has posed looking backwards, really is the decision we sort of made, that our federal government made, to leave the primary scope of the response to the states. And by that I mean two things. I mean, they left the response in terms of what kind of orders. Do we shelter in place? Do we practice social distancing? That's all been left to the individual governors. But also gaining the resources needed to fight the epidemic, the protective equipment, the ventilators, testing, all of those things, masks, we've left pretty much entirely to the states. That's what one would call today a solid federalist approach. We look to the states to solve the problems. I think it was probably a great mistake here. It would have been very easy for the federal government to have taken command of the resource certainly at the first level of the resource allocation. I mean, all the president needed to do was to declare an emergency and get access to really significant amounts of federal emergency funds, even before an authorization from Congress. I could basically have said to the states, we will provide you with all this equipment, but here's the deal. You only get it from us. You can't go out on the market and try to buy it from somebody else. But we'll provide it to you for free, and we have the money to do that. And I think every state would have taken that deal. And that would have allowed the federal government to identify where the things were needed and to get the resources where they needed to be in a coherent way, and without having states bid up against each other. And even now when the federal government obtains equipment, instead of doing what we've traditionally done, which is used FEMA and federal agencies to find the hot spots of distribution, they're turning it over to private companies to sort of let the market decide the distribution. And I just think historically there's no reason to think markets are particularly good at handling public health emergencies. Beyond that, I think early in the epidemic, the federal quarantine power, which is not as broad as the state quarantine power, but does include the power to take actions necessary to prevent disease from getting transmitted across state lines. I think the federal government could have adopted, national shelter-in-place orders, or orders that were phased, through different areas, using epidemiology to think of where future hotspots were going to be and to get ahead of it, which some governors and states in effect did, but some didn't. New York was not that far behind California, but people at this point think, for example, that little bit of far behind has cost a lot of lives. We may see that California may still blow up the way New York did, but New York's hospitals got overwhelmed. And I think the federal government could have done that under its existing quarantine powers early on to prevent the spread. And there's little doubt in my mind that I think if the federal administration had asked Congress for the authority to do that, Congress would have given it to them. And under Congress's power to regulate commerce, it absolutely would have had the power to say, we're the sole distributor, the sole buyer, the sole distributor for emergency health equipment during this time. And I think going forward, two things, right? As social distancing appears to be working some, right? And as states slowly phase out of the greatest restrictions into new restrictions, we're probably going to see more debate about, is this restriction necessary or is that restriction necessary? If Georgia opens up tomorrow, but California stays locked down, are Californians going to say, the governor's off his rocker? And again, I think courts there will tend to defer to where public health is, but the debate's going to get sort of richer. And then the two other things that I think we should at least watch for is, one, what if you have a state, say, for example, Arizona, say Arizona lifts all the limits and blows up the way epidemiologists fear, for example, Georgia or Florida are likely to blow up. Could California stop people at the border? During the Dust Bowl, states tried this. They tried setting up stations at the border to keep people who were coming into the states without jobs out. Now, the Supreme Court said states couldn't do that, but this seems to me to be a very different situation. And I suspect at a minimum that if what the state of California, for example, said was, well, if you're coming from Arizona or from Georgia or Florida, where this is blown up, we're going to take your temperature and we're going to isolate you for 14 days. We're going to quarantine you for 14 days, regardless, before you can go into the state. And I think courts would probably uphold that. But I think we may see a point at which states begin to start trying to block people from other states out. And the other thing that I think we may see is we may see some states, right at the moment, Michigan and California come to mind, but Michigan, New York, and California come to mind, but this may look very different some weeks from now, where a large number of states have loosened restrictions, and the federal administration, the president and the federal administration want the other states to do it as well. And the question is, could they make them do that? And I think the answer is not without an authorization from Congress. That while the federal power to stop spread of a disease would have allowed the federal government to create a federal standard, I don't think that power to stop the disease lets the federal government override states who want to have more restrictive standards. But I think we may see this kind of a conflict between the federal government and some states and this kind of conflict between the states. And that's at least my immediate take on how they'd probably play out.
Yeah. Well, it's all really, really interesting. I hope we don't get to the point where it gets so bad that states are actually locking out citizens from other states. But if we get there, I hope that you will come back and talk to us about that as it's happening. So thank you very much.
Always happy to do that.
For more information and additional resources related to this episode, please visit our website at www.uchastings.edu/pandemic.
And while you're there, you can check out all the episodes in this series. Thanks for listening.